Hello, Bob. How are you today?
I'm good, Peter. Thanks for having me. I appreciate it.
Thanks so much for joining us on our Marcy's Law interview series, Why We Do What We Do. You are a real prosecutorial legend, really all around the country. And as a former prosecutor from Boston, I know you've been to Boston a few times, based on our conversations and how much you love Boston, but not as much as Wisconsin. The work that you have done is really incredible. And I want to get a little bit into your bio, and I just so I don't forget any part of it at all. I want to try to read through it if I can. You are a 45-year, and forgive me for giving that up, a 45-year veteran prosecutor. You started with 9 years as an assistant state's attorney in Cook County in Chicago, in the state's attorney's office. And then in 1987, you came to Madison, Wisconsin as an assistant DA in the felony unit in the Dane County DA's office. It's kind of like when I was looking at your bio, I was thinking of the NCAA these days with the transfer portal. And you were probably one of those blue chip transfers that everyone was looking to get. And they landed you in Dane County in Wisconsin, and you never left the state, which was great for the state of Wisconsin and great for Marcy's Law ultimately, too. And then in 2014, they couldn't keep you in the DA's office any longer, and you joined the Department of Justice in Wisconsin in the criminal litigation unit as an assistant attorney general. Now, as anyone might imagine that hears just the longevity of your career, you've handled a good amount of cases. You've really handled basically every kind of case, every kind of felony, every kind of domestic violence case, as both a trial lawyer and an appellate lawyer. And for those who haven't worked in a legal capacity in the DA's office, or in a prosecutor's office, I can attest to how difficult it is to be both a trial lawyer and an appellate lawyer. To continue on sports metaphors, the way I look at it is almost like being like a Shohei Ohtani, someone who can hit and someone who can pitch at the major league level. It's a rare gem to land in a prosecutor's office. But you've also lectured on really all aspects of prosecution and investigation of crimes, that include major case management, homicides, prosecuting homicides without a body, which I know for a fact as a former homicide prosecutor myself, that is about as challenging as you can get in a murder investigation. Threats crimes, child abuse, sexual assault crimes, gang violence, gang crimes, domestic violence, stalking, the insanity defense, another incredible challenge as a prosecutor when you're confronting an insanity defense, all the rules of evidence, prosecutorial ethics, which is obviously paramount in any office, all aspects of trial practice, witness prep, and plea negotiations. You're certified as a trial advocacy instructor by the National Institute of Trial Advocacy. You were honored by a committee of your peers. And we know how lawyers are very competitive with each other. So that's quite an honor to be honored by your peers at the State Bar of Wisconsin as a Wisconsin Law Fellow. And I should have led with this. At one point in 2001, you were the Wisconsin Prosecutor of the Year. Having said all that, when I put someone in the chair during a trial, you always try to establish their credibility. I think your bio goes over and above as far as establishing any credibility for a witness. So with that, I just want to, I work with prosecutors elected, as well as appointed assistant DAs and assistant attorneys general, all across the country when we go into states to talk about Marcy's Law and how Marcy's Law will help the victims in their state to get meaningful and enforceable constitutional rights for victims. One of the questions that comes back from prosecutors a lot is, how is this going to impact my office? How's it going to impact the budget? Is this really going to help? And the other thing is, what's this going to look like after you and the Marcy's Law team leaves? And what I try to tell prosecutors and anybody involved in the actual passage of Marcy's Law is that when we pass Marcy's Law, which we did in Wisconsin, by the way, with 75% of the vote, with the help of people like you and advocates like you. When we pass Marcy's Law, it is not, for Marcy's Law in our organization, mission accomplished. It's more like mission begun. And so could you tell people, for starters, what that partnership looks like between prosecutors' offices, victims' rights organizations, and the Marcy's Law infrastructure that we keep in place in states where Marcy's Law is passed, specifically Wisconsin?
Right. And Peter, I can say that when I was able to work with Nella Kalpic, we just call her Nella because in Wisconsin, she's like Madonna. She's got one word, Nella, and everyone associates Nella with victim rights in Wisconsin. She's the face of victim rights in Wisconsin. When she reached out to me, we knew each other from a statute that we worked on that made it an aggravating factor in domestic violence cases for an offender to do it in front of children, for the children to hear it or see it. And we made it an aggravating factor in Wisconsin. She worked on that when she was on staff in the state legislature. When she came over to Marsy's Law, she reached out to me. She said, "Hey, I'm not a lawyer. I get questions from attorneys and from other people. Can you help me out with this?" And I said, "Absolutely. We're working on trying to get victims' rights to be constitutional, and I'm going to do that." So we campaigned in 2019, 2020. For people who are worried about the implementation of Marsy's Law, let me just say our Marsy's Law passed in April and went into effect on May 6th of 2020. In case anyone's forgotten, we were in the middle of a pandemic when that happened. So we had to adjust a lot of things that we might not have had to have done. But as you have said, Nella, who still to this day, she and I in a couple of weeks will be doing a presentation on victim rights at a conference for victim service organizations. Nella reached out to us, we reached out to her, and we began the partnership that you're talking about. And she hasn't ever left our side. In order to bring awareness of the constitutional amendment, as you said, passed by 75% of the voting populace when it was passed, but bringing awareness to all 72 counties and to as many people in the county as we can. Nella has developed what we call the Silhouette Project. So she has literally life-size or bigger silhouettes of people in various positions, but they're just a silhouette of men, women, children, and each silhouette represents a right that's in our constitutional amendment. And she gains permission to display these life-size silhouettes in courthouse front yards, in parks near courthouses, in the vicinity of a victim rights organization, wherever she can get the most play, the most populace to walk past it. She arranges to have interviews with news organizations who come and ask her about this, and she tells them her story as a victim, and she tells them the story of so many thousands of victims that she has talked to since she's been here. And this project loads it up in a truck and takes it there and gets it where it needs to be. And it's just a wonderful thing to humanize these rights and to make people aware of them. The other part of her work is that she thought of, that she created, and she brought to many counties in our state, including Milwaukee, our largest county, is called the mapping exercise. And in this mapping exercise that she developed, we put all of the stakeholders, to use a more modern term maybe than what I'm used to, but put all the stakeholders in the room. We're not talking about people who fly at 30,000 feet. We're talking about the people on the ground who work with victims and their immediate supervisors, and talk to them about getting, as it's a mapping. So we get the victim from the moment of victimization, which is when in our Constitution, when their rights become their rights, is at the moment of victimization, all the way through to the end of the time that they are subjected to the system. So that includes people who are probation and parole officers, and all of those people are given an opportunity to come to know what rights in this constitutional amendment apply to them in their particular space along the victim's path. So it's an incredibly helpful opportunity to get everybody in a room together, exchange cards, come to know people maybe you didn't know before, maybe you didn't understand what their job was, and bring people together and have them come to know, first of all, what the rights are. I have copies of our amendment. I carry it around with me everywhere I go. And that way, when people talk to me about it, I can go right to the words. Our amendment's pretty long. And in fact, it's the longest actual article in our Constitution in Wisconsin. But it lays it out, I think, in pretty clear language. So when people are talking about implementation, when people are talking about working with Marsy's Law, as I said, Nella's the face of victim rights in Wisconsin, and I'm proud every day to have a conversation with her and to work with her. in that role. I can talk about other folks who were involved in the implementation if you'd like.
Yes, I'd love you to do that. And before
Okay,
you do
so
that, but before you do
yep,
that, when you talk about Nella being the face of victims' rights, it's we are so blessed to have Nella. Nella's story is incredible, and we have had Nella tell her story on this interview series before. It's very compelling, and and so many times when there are survivors or victims in the system, um, people just don't understand what they're going through. Nella can. She's been there, and she says, "I understand." Um, and when you talk about the face, it's one of the things that Nella talks about, bringing people together, is to be able to actually put literal faces to names and not just have someone from probation that just appears on your computer screen with an extension in an office, and you call them and you say, "Oh, okay, this is the way Marsy's Law works." Instead, uh, Nella has made a point of making personal relationships with all of the, as you said, stakeholders. So they are people that are all part of the same kind of mission, and people that Nella now knows, not just in Milwaukee, but all around the state. And I will tell you that the feeling is mutual when I talk to Nella about the people who work with her and have really been helpful in the success of Marsy's Law. The first name from a prosecutorial standpoint that came to her mind, she didn't even think it was Bob Kaiser. So
well, yeah,
it's really been a great partnership.
it's important that people understand that that a Marcy's Law staff like Nella, who, as I said, we have 72 counties. I guarantee you, she has a personal relationship with 72 sheriffs. Period. That's just the way it is. That's how she is. She knows every district attorney. She knows the important assistant and deputy district attorneys. And victim witness people, of course, one of the stories I tell is the fact that when I started in this business, there was no such thing as a victim witness professional. When I was in Chicago, I had to do that job, and people who come to know me are glad that there's now victim witness people. When it was my job to get people to come to court on the south side of Chicago, that was a really bad idea. So though they were just getting started, and now the victim witness people know that they can reach out to her. One of the parts of our implementation, because it was the middle of COVID, so we couldn't like go out and talk to people, right? So what we did at the Department of Justice was we set up a hotline. So people think of a hotline being on the phone. People could call us, but we had an email hotline, and it was manned by three people. It was manned by an attorney who was the head of our Office of Crime Victim Services, had been my supervisor as a prosecutor in Dane County. It was manned by myself on behalf of prosecutors, and it was manned by another prosecutor, a 30-year veteran sexual assault prosecutor from Milwaukee, who was now the head of on boots on the ground training and standards for police officers. And the three of us manned this hotline. And for months and months and months, questions constantly came in. We would staff them and we would respond to them in writing with whatever we had. We would do research on Marsy's Law in other states. We would say, hey, one of the things that's important to understand in Wisconsin was much, not all, but much of what is in our Constitution now was in what we used to refer to colloquially as Chapter 950. Chapter 950 was our victim rights statute. We had a very short one-paragraph victim rights law in our Constitution that basically said, and none of this means anything until they pass a statute. Well, when our Constitution, when our Marsy's Law was passed, our Marsy's Law says this amendment is self-executing. No further laws need to be passed. Follow what the amendment says is essentially what it comes down to. But so we did that, and we did that in conjunction with Nella. We did presentations, we did conferences, we did Friday afternoon lunch times. We went to, when finally we could all be together, we went to conferences for the police, we went to conferences for prosecutors. We worked closely with the judges' educational arm. Some people were allowed to go talk to judges. I wasn't allowed to go talk to judges about victim rights because people thought I was prejudiced. But the head of our Office of Crime Victim Services was, and so was our person from Training and Standards. So we worked with the judges and the clerk staff to try to get them to understand what these rights are. So and Nella was integral to that. Nella developed in our state a a virtual victim rights conference. So even after Marsy's Law was over, we still have a virtual victim rights conference, and we have it every year. And this year, Nella brought in victim rights advocates from around the world, from England, South Africa, to come and talk to us about, The Hague and victim rights in other countries, and how they are or aren't enforced. And so that conference reaches out to I think the first time we did it, we had 500 people attend. So, taking advantage of the opportunity that this kind of forum allows us to get the word out. And again, another idea of Nella's that she implemented, got us all involved in it. We had a committee, and we got people to come and do presentations. So every opportunity that we have to alert people to the rights in our constitutional amendment, we do, and we do it in partnership with Nella. And she works very, very hard to make sure that here in Wisconsin, we are aware of our rights.
And you said you were going to just tell us a little bit about a couple of the other relationships that have been helpful with you with respect to educating people in the implementation of Marsy's Law.
Right. Well, so, one of the things that we were able to do with this hotline was to find out what some of the issues were that people were confronted with. And as we all know, just like there aren't enough police, there aren't enough prosecutors. And so trying our best to provide people with guidance. One of the things that we did at the Department of Justice, again, in conjunction with training and standards, which focuses on the police, in conjunction with the criminal litigation unit, which focused on prosecutors, and the Office of Crime Victim Services, which focused on victim witness units, we were able to provide DA's offices, which suggested best practices as a protocol, but also suggested best practices templates. And so, for instance, one of the rights in our amendment is that if it comes to be that a person who would be technically a victim because the victim is a child or the victim is a disabled person, but it comes to anyone's attention fairly quickly, usually, that they're not acting in the best interest, let's say, of the child, we have the ability in our amendment to go to court and to move to keep that person from implementing or being accorded any victim's rights on behalf of that child. And where we've gotten to now is we have people that can be appointed to act in that role. And so that's just an example of a place where we have a template to make that motion to court. And so, and we have other templates. We spend a lot of time. We are the only state with a freestanding right to privacy. That's literally the victim has a right to privacy. And we take a lot of criticism about that. Well, what the hell does that mean? Well, you know what? You could have asked in 1865, what does equal protection and due process mean, right? We're finding out. We were able to use that right to privacy to overturn a law. Prosecutors in the room, get ready for this. It used to be the law in Wisconsin that if a sexual assault victim complained and the defense believed that they had been seen by a psychiatrist or a psychologist, that unless the defense was given those records, that the victim wasn't allowed to testify. I hope everyone is shocked, but because of victim right to privacy in Marsy's Law, that 33-year-old rule in Wisconsin case law was overturned. And so, don't tell me we don't know what privacy means. We do know what it means. We've known ever since Caldwell versus Georgia. So I think that people will come to know that, yes, there are phrases in any constitutional amendment, be it the United States or a state, that need to be fleshed out. And we do that with case law. We do that by bringing cases. And obviously an incredibly important group of people with whom Nella has an absolute personal relationship with every single one of them in our state are our victim rights lawyers. And we have 3 law firms in our state that literally their focus of their practice is victims' rights. And Nella has worked with them. She has helped bring them to the table with prosecutors so that we can find our way, find our role between each other to get to the place where, as an advocate on behalf of the state, I might need to advocate for something that a victim feels they don't want to be advocated for. They have the right to be heard under our Constitution when their rights are implicated, and they can be heard themselves or with their attorney. And so we work closely with them. But when there's the potential for some friction there, we all know we can turn to Nella. And Nella has a personal relationship with those people, and she'll be able to help us bring all of us to the table to have it work the best for the victims. So I think that's just another example of the kind of work that gets done. When people are considering whatever form of the amendment you have, and I do recommend people take a look at Wisconsin's version. It's very thorough. It's very complete. Again, it was somewhat modeled on the statutes we already had. But we added some things to it. And one of the most important things is actually a thing that goes to the origins of Marsy's Law to begin with, which is the victim's ability to be heard at a bail hearing. We didn't have that before. That was not in our statute. It has to do with the origins of Marsy's Law. And now victims are heard at a bail hearing. Now, is that a mad scramble by a prosecutor's office? Because remember, for all the prosecutors in the room, when I started in this business, there was no Riverside case. There was no, get people to court in 48 hours. We got them there eventually in Chicago, which was a busy place. I was doing bail hearings at 7 o'clock in the morning on Saturdays and Sundays after Friday night and Saturday night arrest things happen. But so yes, is that a lot of work for victim witness people in a big place like Milwaukee or Madison to get people to know that there's going to be a court hearing in 48 hours or shortly thereafter, and they have the opportunity to say something at bail hearings? But they are there, and they do. And oh, by the way, that's not always in our favor, and we have to remember that for those of us who everybody should be on our side, everybody's not always on our side. I was a domestic violence prosecutor. I still consider myself a domestic violence prosecutor for many, many years. It was my bread and butter. It was what I truly believed in, what I wanted to do. And so victims come in and say things opposite of what we say. They have the right to be heard. And reminding people they don't have the right to have what they want. They have the right to be heard and to have the judge consider what they say in making a decision. But certainly the opposite can happen as well. We always had a right to speak at sentencing. Maybe some states the victim doesn't have a right to speak at sentencing. I can't imagine that. But if they don't, and that's in your amendment, then certainly the victims should be able to be heard at sentencing. So, just so many examples of making sure, just as an example, we had a statute where victims were to be consulted about court dates. Prosecutors in the room know that speedy trial may have been a defendant's right alone and no one else. Speedy trials are not always to the defendant's advantage. People die, people disappear, people get intimidated. Defendants may not want a speedy trial. In our constitutional amendment, the victims have the right, and of course, why should I make it up? I'll just read it, to proceedings free from unreasonable delay and to timely disposition of the case free from unreasonable delay. That's now their constitutional right. And we get to invoke that when the defendant asks for the umpteen millionth continuance or the umpteen millionth change of attorneys. And we get to stand up and say, you know what? My victim has not just a right to a speedy trial, a constitutional right to a speedy trial. And that's what we're asking the court to do. And if you ignore this under our amendment, the victim has the right, either themselves, through their attorney, or through the prosecutor, to seek enforcement of their right by going to this court and saying, hey, I'm telling you, my right's being violated. And if you're not going to do something about it, you have to explain to me why you're not doing anything. And if you still don't do anything, I can take you up to the Court of Appeals and get you overturned. And actually, the victim's right to bring up their privacy is how that case that got that terrible case law overturned in Wisconsin came about. The prosecutor wasn't opposing the turning over records, but the victim's lawyer was. That case went to the Wisconsin Supreme Court and that got that overturned. So these are opportunities that victims have, not to be a party to the case. No one's making them a party, but to have a part in the case, to have their part be heard, and to have their part be heard clearly in the courtroom and regularly. In other words, making this a regular and routine part of everything we do every day. It's important to understand that I've been doing this a long time. And I can change, I can adjust, I can do what needs to be done to see to it that victims' rights are observed. Everyone else can do it too. All right. That's all there is to it. It's just not that hard. Do what needs to be done. Yes. Are there budgetary considerations? I'll just take a second to mention that there was complaining after the amendment passed that because it's a constitutional amendment, nobody costed it out at the legislature. And certainly if somebody's talking about doing this, they should spend some time talking about what the cost may be. But to me, you should have been doing this stuff anyway. We had it as a statute. We had victim rights advocates. We had victim witness professionals are a huge part of our work in Wisconsin. These are such important people. So if there's some part of the amendment that looks like it's going to be a greater imposition, then one needs to alert your where you get your money from about that. But It shouldn't be. These are things that don't cost more, and they're just things that should be happening. Victims should be being told when a court date is. However, you go about doing that. Victims should have an opportunity to say, "Hey, I can't be there that day. I can't get off work that day. It needs to be another day. I can't get a babysitter." We need to be able to have those kinds of conversations in a calm and manner, but those kinds of accommodations need to be made so the victims can be as present in court as a defendant is. And we know the defendant's always there. Victims need to be there too. So the right to be present, to me, is so important because then I get to have a conversation with the victim about what happened and tell them about what happened and get them to understand what happened. And that's my job. It's one of the things I love about criminal law. I don't have to worry about, Wall Street. Who can understand what the hell's going on there? The great thing about criminal law is it's just not that hard. People can understand about what we're doing if you take the time to explain it to them. And they deserve that, and they have the right to that under our Constitution, and they should in everybody's state.
Yeah, and the prosecutors who do this job the right way, like you do, it is important to note, like you just said, that this doesn't really invent anything new for prosecutors as far as what they should be doing in their office. What it really does, and what I would say, what I've said to prosecutors is this is something that will highlight the great work that you're already doing with respect to bringing victims into the fold and actually give victims more rights constitutionally enshrined. Like, for instance, the right to a speedy trial. I think so many times prior to a victim having a constitutional right to a speedy trial, they would look time and time again, they would take off work, they would get a babysitter, they would come in, and they'd see ironically enough, the defendant who has the constitutional right to a speedy trial, look for a continuance, look for another continuance, wait till the trial date and you're about to pick a jury, and then tell the judge, I want a new lawyer, because they realize then it's going to be another year. And so now the victim and the victim's family and the survivors can say, okay, enough is enough with these delays. We actually have a constitutional right to justice and to a speedy trial.
Sure.
The other things you said, absolutely, which I think are really great points, and I like the way you said it, that the victim is not automatically, or the victim is not brought in as a party to the case, but they are a part and a significant part of the case. And when you talked about the friction sometimes, because it's not always, the victim and the victim's family may not always be on the same page from a prosecutorial strategy standpoint as the prosecutor with respect to the case and the different variables that will come in with respect to the provability and which witnesses will come in and are available, or even at a bail hearing. You might not always be on the same page. And it's interesting you said that Nella is very good at diffusing such friction. It's always nice to have somebody that can do that. Sometimes it can be the prosecutor. Other times it needs to be a victim witness advocate or someone like Nella or Marsy's law person as well. What we usually typically say to victims with respect to Marsy's law is you will have a voice, but not a veto. And so there will be some scenarios where, for instance, a plea negotiation, there will be an agreed upon plea recommendation with the defense and the prosecution, and the victim may part company and may take exception to what the recommendation is. But this does not mean that they will tell a prosecutor how to prosecute their case. But they will have a voice, and if they disagree, the judge will be constitutionally required to say, okay, Madam Victim, I would like to hear from you now.
And we had that statutorily previously, but now they have the constitutional right to speak to us. And so, not that I wouldn't have done it. I always, on major cases, always spoke with my victim beforehand before I made an offer to make sure that I understood what their position was going to be on that. But now with the Constitution, a constitutional amendment, they get to be heard. The example I always use actually is pre-Marsy's law, but we've never had the death penalty in Wisconsin. It was not even in the first constitutional amendment. Had a man get killed. And for the three the defendants who pled, and the mother came in of the man who was killed and said she wanted the death penalty, and the judge listened to her, and then she went and sat down, and we went through this 3 times. She gets to say that. If that's what she wants to say, she gets to say it. But we can have victims in a domestic violence case want less than what we've asked for and tell the judge reasons, and the judge gets to consider what they say. And that's good. we want the judge to consider what they say. And we see that on television a lot all across the country. So I think as a matter of statutory law across the country, it's happening. To have it be a constitutional right, I think, as you say, the word is enshrined. And that's really what is important about having victims' rights be in the Constitution, is they are enshrined in a Constitution. And then the prosecutor has that as the aspect of of talking about the victims' rights that you don't have without an amendment. With the amendment, those rights are enshrined. They're there. They've been voted on by the people in the state. They've been decided that that's what it's going to be, and victims can be confident that they're going to be enforced when they're constitutional.
Well, Bob, I want to thank you for being so generous with your time, and most of all, for giving us a firsthand account of what Marsy's Law looks like after it has been passed. We are now in other states. We are now working in Tennessee, where we are marching forward toward a constitutional amendment in Marsy's Law in Tennessee. And we have states where we have passed it prior to Wisconsin, and there'll be more states. And yours is a perfect example, and I'm glad that you were able to illustrate it for us, that, like I said before, when Marsy's Law is passed in a state, our work hasn't finished. It really has just begun. And this is how the partnership looks. This is how the partnership works in a state where Marsy's Law has been passed. And you really are a prosecutor's prosecutor. You know, first and foremost, you're a seeker of justice, and that's clear from your record. It's clear from what everyone says about your work throughout 4 decades plus of being a prosecutor. And what that also means is you are a champion for victims, and you continue to be. And we are so blessed that. And one of the things, I saw a quote that when someone was asking you about Marsy's Law, and you said, and what you do and how you explain Marsy's Law, you said, we make it clear to victims that Marsy's Law gives them constitutional rights which will be supportive of their efforts to survive and come out stronger. And that was just so well put. And I just want to thank you for continuing to work with us, not just in Wisconsin, but really to just be a voice for states really around the country on how important it is to pass Marsy's Law.
That's right. And I'm here for you. If anybody wants to reach out to me, they can get my information from you, and I'll be happy to talk to them about what we've done here.
Really appreciate it. Thank you so much, Bob, and enjoy the rest of the summer.
All right, Peter. Good talking to you. You take care too. Talk to you soon.
Great talking to you. Thank you very much.
Bye-bye.
Bye-bye.